malinaw that this is about the court. This is about the judiciary, the Supreme Court defending the judiciary. That's very clear. I'm just wondering, nonetheless, that you have a baseline here, di ba? The baseline is what, however you want to define what Lorraine Badoy did and said. And then you have the threatened action. And basically that, and it says that, that inciting violence through whatever you would call that act, and let's call it words, diba? Inciting violence with words through social media and other means that endanger the lives of judges and their families. Will not tolerate that. No? And that is going to be actionable. But if you took away the word judges and basically said that threaten the lives of people, I guess my question is, does this also help to draw a line in the sand for other people of other sectors who say that, we're not the judiciary, but we've been saying this all along, and we do want this acted upon, and we do want to take action against a person for essentially the same thing that Lorraine Badoy did. The only difference is that I'm not a judge. Does this somehow, coming from the Supreme Court, does this somehow draw a line in the sand or help us to define how we are going to take action against people who are essentially attacking us the same way?
Yes, I think it does, because especially now, though, and then in the past couple of years, we have seen how information and how certain influencers and bloggers have tried to control the narrative and control information that goes to people, and that in the past it has always been said that the right to freedom of expression is one of the most closely guarded civil liberty, and rightly so. But the Supreme Court, in that case I mentioned also earlier, has highlighted that, as we all know, no right is absolute. And so for private persons also, when they are subject to certain utterances, publications, especially in social media, when they find themselves in the opposite side of the fence of these so-called influencers, that they can take action against statements or accusations against them, because this kind of speech is not protected by law when it causes harm already to other people. And so this is not only for judges and lawyers and journalists, only that in this case there is one paramount public interest other than one's private interest of protecting your reputation. Here, the paramount public interest is for judicial system. But for private people, that is also a very important private interest, that we protect our reputation, even our personal safety. And so we should not just tolerate these kinds of statements when they attack us with falsehood and baseless accusations that might cause our harm to us.
Sir, but just to follow up on Robbie's earlier question, here kasi we're talking about a statement from the Supreme Court warning people against issuing threats to members of the judiciary and their families, and stating that you may be held in contempt of court. So that's pretty clear.
Yes.
But when it comes to private citizens, and when they are faced with similar kinds of occurrences, incidents, or allegations, what is their recourse? Anong pwede nilang gawin? Kasi, of course, iba naman yung contempt of court. Contempt of court is for example, courts and judges. But for private citizens, if, for example, hypothetically, if somebody tells Robbie, what if I kill you and claim that I am immune from suit because I did it out of my political ideology? So what is Robbie's recourse? And what is his recourse vis-a-vis what the court said today? Meron ho bang may nagbago ho ba?
Well, private persons are subjected to also baseless accusations already. criminal or even civil cases in court to vindicate the violation of their rights. And much more when there's already a threat of bodily harm. So they have the remedy to go to court for those threats and file criminal charges as well.